This case is Ma and Secretary with Social Security at a federal court case. Appeal from AAT tied to decision on error of law. Period 1. Building study. Error of law number 1. Made decision with insufficient evidence by not knowing hour allocated to subject study constitute error of law under Section 51H and 61H of the ADJR Act. AAT decision, paragraph 35. On 31 March 2023, the Secretary received a response from ASQA indicate that the applicant enrolled in a certificate 4 in building and construction with Building Institute of Training and Development on 3 November 2008. The applicant completed 2 units by 23 April 2010, and no qualification was assured. Paragraph 37. He proposed use a TAFE New South Wales time allocation for the equivalent course to map the hour study in a Building Institute course, as the Building Institute course has closed and there was no public available information for the number of hours for the course from the Building Institute. In paragraph 40, the information provided by ASQA does not include the hour of study completed by the applicant, but is sufficient to support a finding that applicant did not meet activity tests in relation to the study. Now I consider the AAT decision failed to consider the relevant evidence provided to Centrelink as program map. What state of the program at the relevant time, and also failed to consider 2 additional units complete on the 1st of June 2012. Relevant case law, Dolenstein and Secretary, Department of Education, Employment and Workplace Relationship, 2010 AATA 435. On paragraph 22, for Ms. Dolenstein to be entitled to a study, she would have to satisfy the requirement set out in Part 2.11a of the Act. There is insufficient evidence before me to make a decision as whether Mr. Dolenstein will meet this requirement. In paragraph 24, I limit the matter to the respondent for the purpose of determining whether, pursuant to Part 2.11a of the Act, Mr. Dolenstein qualified for all study payment from 2 March 2009 to 24 May 2009. And now I discuss error of law number 2. This is fail to consider relevant special subsequency or sole administration error to waive the debt. The applicant applied or study on March 2011 and was rejected. The respondent, in writing, required all study the applicant complete and currently study on April 2011. The applicant provided written record of his current study, including Building Institute and TAFE, as concurrent study. The respondent failed to conduct a timely qualification check, which constitutes a special subsequency warrant waive of a debt. Now I turn to the relevant case law, Anderson and Secretary, Department of Education, Science and Training, 2006 AATA 589. On paragraph 40, it says, the Commonwealth commit a series of administrative errors that constitute special subsequency. Centrelink failed to verify Mr. Anderson's enrollment at a university or his stature as a student when assessing his or study claim. Centrelink failed to act in a timely manner on information in his possession concerning Mr. Anderson's study workload. Centrelink's review of Mr. Anderson's case was fragmented and was not complete in a timely manner. I am certified that the errors of Commonwealth are at the extreme and constitute special subsequency. Now I discuss special subsequency on paragraph 39 of the AAT decision. The AAT said the term special subsequency is not defined but includes subsequency that are unusual, uncommon, or exceptional. Refer to Benlow with Director General of Social Security, 1984 AATA 176. Say, or if something unfair, unintended, or unjust occur as a result of the application of the relevant provision or principle of liability under the Act. He referred goes with Secretary, Department of Social Security in 1995, FCA 1708 at paragraph 545. Now the Building Institute closed 2012 beyond the applicant control, leave an evidence gap due to the respondent failed to conduct a timely check. AAT decision. It says 1237A provide for waiver of debt attributable to administrative error. Administrative error 1 is subject to subsection 1A. The Secretary must waive the right to recover the proportion of debt that is attributable solely to an administrative error made by the Commonwealth if the debtor received in good faith the payment or payment that gives right to the proportion of the debt. In order to the debt to be waived under 1237A of the Act, the debt must be attributable solely to administrative error. There is no evidence that the debt in this matter was caused solely by administrative error. He further continued, Section 1237AAD provide for waive of all or part of the debt in special subsequency. 1237AAD waiver in special subsequency, the Secretary may waive the right to recover all or part of the debt if the Secretary is certified that A. The debt did not result wholly or partly from debtor or any other person negligently, I. made a false statement or false representation, or fail or omit to complete with the provision of the Act, the Administration Act, or the 1947 Act, and B. There is a special subsequency other than financial hardship alone that made it decidable to waive, and C. is more appropriate to waive than right of the debt or part of the debt. I note that each of the three elements in this section must be certified before the declaration to waive may be exercised. The term special subsequency is not defined in the Act, but should take into account all of the person's subsequency and would usually based on combination of factors. The signatory contend that applicant finance subsequency are not sufficient unusual, uncommon, or exceptional so as to make his case special. Now, the AAT failed to consider administrative error and building institute clause, leading impossible to obtain transcript, and even beyond the applicant control, lead to unfair, unjustified outcome, where the applicant completed study but could not prove it as a special subsequency. AAT decision, paragraph 55 and 56. The AAT improperly accepted the waive of the debt by considering financial hardship alone. The act special other than financial hardship alone, and failed to consider other special subsequences, such as administrative error, failed to conduct a qualification check in a timely manner, and a building institute closed beyond the applicant control.